the separation of church and state. It's one of the founding principles of this country. But now the Trump administration wants to blur the line and allow religious organizations like churches to get involved more heavily in politics with direct endorsements and keep their tax-exempt status. So here's what's going on. In August of last year, a group of churches, along with the National Religious Broadcasters and a religious nonprofit, filed a lawsuit in federal court in the Eastern District of Texas against the IRS. In that lawsuit, the plaintiffs say the 1954 amendment to the federal tax code, called the Johnson Amendment, is completely unfair because it prohibits religious organizations specifically from supporting or opposing candidates for public office, including making statements about those candidates. The plaintiffs say that discriminates against religious organizations and violates their First Amendment rights. They say they should be able to keep their tax-exempt status and be able to support or oppose publicly whichever candidate they want to their flock through any means they choose. Under the Biden administration, in December of last year, the Department of Justice, on behalf of the IRS, responded to this lawsuit saying this group is grasping at straws. They are asking for a solution to a problem that does not exist because no one from the government has stopped them from any of their activities. And on top of that, hello, church and state, there is no reason why American taxpayers should be subsidizing what amounts to lobbying or political activity by giving these churches tax-exempt status. Basically said, they can't have it both ways. The Biden DOJ asked the judge to dismiss the case. Now, real quick, before I go any further, you need to understand how the law works. In 1954, the Johnson Amendment was passed by Congress and added to the tax code. It says all 501c3 organizations like charities and churches are absolutely prohibited from directly or indirectly participating in or intervening in any political campaign on behalf of or in opposition to any candidate for elective public office. Contributions to political campaign funds or public statements of position, verbal or written, made on behalf of the organization in favor of or in opposition to any candidate for public office clearly violates the prohibition against political campaign activity. Violating this prohibition may result in denial or revocation of tax-exempt status. Now, the tax code does allow these 501c3 organizations to have voter registration or get out the vote drives and certain educational activities related to elections as long as they are done in a nonpartisan way. This amendment at the time was not controversial, and the organizations believed it was a small price to pay to not have to pay any taxes. It's also worth noting that over the years, the IRS has been pretty reluctant to enforce the Johnson Amendment. They've often turned a blind eye to blatant violations of it and have exempted certain political activities by church leaders outside of normal church proceedings. That's why the Biden administration said this lawsuit was a solution in search of a problem. Well, as you know, in January, the Trump administration took over. And just 2 weeks ago, the Trump Department of Justice decided to take a different stance on this case. Instead of fighting it, they have decided to make an agreement with this religious group that is suing and reinterpret the Johnson Amendment. In the consent decree, the Trump administration says the new policy will be when churches, through their religious teachings, endorse or oppose a particular candidate, and they do it through their customary channels of communication, including from the pulpit, that will not be considered participating in or intervening in campaigns. And it's not really campaign activity anyway, it's more like a family discussion. So these churches should be able to do that and keep their tax-exempt status. Now, this is not a done deal. In order for any of this to actually go through, the Texas federal judge overseeing this case needs to go over the legality of what has been agreed to and either accept or reject the consent decree. There is no telling when the judge is going to rule on this.